instances where the firm knows who that person is, I would really, really encourage the company to ask him or her if they would sit down for an interview. And the reason I say that is because you can, first of all, learn a lot that would allow you to improve your own internal policies and controls to the extent that the whistleblower's claim has any merit. You also get an opportunity to understand exactly where the whistleblower is coming from. You can box him or her out. You can narrow the scope of the complaint. You can make sure that there is nothing else, so there's no surprises later on. The third reason is that under Rule 21F, there are limitations to what a whistleblower can recover based on his or her own involvement in the conduct. So by sitting down with the whistleblower and saying, we'd like to know what your concerns are and who you are and where you're going with this, you can learn an awful lot about that person's motivation. You can learn whether or not they were planning on leaving the company anyway. You can learn whether they're themselves a rogue employee or somebody who engaged in criminal conduct. And knowing that information ahead of time really helps you posture your company when you're negotiating with the SEC. It depends on the stage of the investigation. The SEC has an obligation at some point, if it's going to go forward with its inquiry, to let the firm know that there has been a whistleblower complaint. They don't have to disclose the identity of the whistleblower right away, but oftentimes you can get a sense from the staff attorney at least what department the individual is from, and then conduct your own internal investigation. I'm not suggesting for 1 second that the firm should go on a witch hunt and try and figure out who that individual is. But in the spirit of taking remedial measures and trying to get to the bottom of the conduct and determine, again, if it's a problem with corporate culture or just maybe a rogue employee, you can get some information from the staff and then do your own internal investigation to develop it. So if you decide that you want to go forward to the SEC and proactively cooperate, so if you've got a whistleblower who's raised a concern that has some merit and you've decided that you want to negotiate with the SEC, there are a few things that I would recommend that you do. First, as we discussed earlier, you've got to talk to the whistleblower and really understand what his or her concerns are. Second, you need to make sure you understand who the staff attorney is, what the scope of their investigation is, so that you're not giving them information that they're not investigating. You don't want them to turn over stones that they wouldn't otherwise turn over. But third, and most important, I think, is when you go to meet with the SEC or DOJ, if they've invited them along, you really need to focus your presentation on what factors they are considering in deciding whether to take any action on the whistleblower's complaint. And I say that having come from law enforcement and realizing that the best presentations that I received on the law enforcement side were from people who were doing my job for me. So they came in with relevant case law, facts that I had no way of knowing about, even from the whistleblower, and considerations that I needed to make as I was pitching a resolution to my superiors. There is a memo, it's in the U.S. Attorney's Manual, it's Chapter 9, subsection 28. It's called the Phillip Memo, affectionately named after the latest Deputy Attorney General who's weighed in on it. But it lists 8 factors that the U.S. Attorney's Office must consider in deciding whether to charge a corporation. When we had parallel investigations with the SEC, we often said to them, here are the factors that we're going to consider, and they said, great, these are the factors we consider as well. Maybe not specifically these 8, but definitely factors that go into a decision whether to pursue a complaint. There are additional costs that come in a couple of different ways. First is costs associated with an internal investigation. To just get to the bottom of the conduct, you've got 120 days to investigate whether there actually was some wrongdoing and make your own disclosure to the SEC if you decide to go that route. That's not free. So it's a cost in setting aside other business ventures, distracting compliance officers in a manner that they may not otherwise have planned for. There's also a cost in retaining the right person to negotiate with the SEC. And you're going to want to do that. You're going to want to find somebody who knows the individuals in the relevant office and who has some credibility with the staff attorneys and can really negotiate with them and paint the company in the best possible light. Depends on who you ask. The SEC, I think, quite earnestly sees this as an opportunity to get to the bottom of fraud and abuse that they otherwise would not detect. It's very, very common practice in law enforcement to get people on the inside of a company to come forward and cooperate with the government and provide information that they otherwise would not have access to. On the other side, I think that it's a little too soon to tell. We're really, really hoping that people still feel like they can be comfortable in coming forward to internal compliance reporting chains and say, look, there's a problem that I see. I'd like you to remediate it. I'd like you to address it and really work together to solve that problem. Unfortunately, when you've got a bounty involved, the incentives are really not in favor of that approach. So our hope is that people will come forward, give the company 120 days to do their thorough investigation, remediate what issues are there, and the SEC doesn't have to step in. That's a bit of a happy ending, I think, but it really accomplishes what the SEC at least says are its laudable goals, which is to get rid of fraud and abuse in the financial sector. And so everybody wants to do that. Fraud and abuse is expensive. It detracts corporations from their ultimate goal, which is to bring benefit to the shareholders and contribute positively to the economy. So we'll see what happens.